But here's the key. DOJ has a professional voting section staff. Some of them have been there 30 or 35 years. They understand the law. They have lawyers. They have demographers. They have mappers. They have every piece of software that anybody uses in the United States to map or redistrict with. They can draw their own plans, and they will. And the standard is whether a fairly drawn alternative plan, other than the one you've submitted, can result in less retrogression than your plan. And they will look. And they may enter an objection to your plan instead of pre-clearing it, if there is such a choice and you do not articulate in the pre-clearance submission reasons why you have made those choices that are convincing to them. The burden is on the city to show that a less retrogressive plan is not a reasonable alternative. And that's one of the discussions that goes on in the pre-clearance submission. One of the reasons it's so complicated. And here's a point that's important. As I will describe in a minute, you can also be liable for Voting Rights Act violations under Section 2, the anti-discrimination provision. Getting a plan pre-cleared under Section 5 does not give you a get-out-of-jail-free card with respect to Section 2 liability. It only satisfies the Section 5 pre-clearance standard. Okay, an important point. So we will also want to consider Section 2 when you draw. We will want to be conscious of the standard. Section 2, as I said, the General Anti-Discrimination Statute in the Voting Rights Act. In general, there are lots of ways to violate Section 2, but the ones that come up in redistricting the most commonly are called cracking and packing. Cracking is also sometimes known as fracturing, and the idea is you have a large, relatively geographically compact group of minority voters, and you split them up into multiple districts in order to reduce their relative voting power in any one district. Packing is the opposite practice. It's taking a numerous minority population, which could influence or even be a majority group in more than one district, and literally packing them into a single district, again, with the effect of minimizing their voting power. Both of those are to be avoided. The 14th Amendment is the last of the four legal principles that apply. And it's kind of an opposite principle. It puts a limit on the degree to which, in redistricting, you may be conscious of race and elevate race to the primary decision basis for your districts. One way of thinking about it is that it puts a limit on the amount of racial gerrymandering you can do. That's not all it does. The question that the courts ask is whether or not you had a legitimate government purpose for considering race in the redistricting process. And the Supreme Court has told us in several cases that satisfying Section 5, non-retrogression, and satisfying Section 2, avoiding Section 2 liability, are both compelling governmental interests that are valid reasons to consider race when redistricting. But the test is whether you use race during redistricting to the least amount you can while still satisfying those standards. Here is an example of what not to do. This is a North Carolina district drawn in 1992 by the state legislature in order to try to create an African American district. The yellow district, labeled 12, followed an interstate highway across most of the state and grabbed every little African American community it could find along the way to create a majority African American district. It was challenged in court, and the Supreme Court said this goes too far. You're not required to do this kind of gerrymandering. This elevates the racial consideration to a level that's unacceptable. That case called Shaw versus Reno, there have been a number of them since. They're all loosely called the Shaw cases, and they set out that standard. This is an example closer to home. These are districts in Houston, congressional districts that were drawn in the area around the city of Houston's predominantly African American district and predominantly Hispanic district. The light green is a Hispanic district, the dark red an African American one. You can see the legislature did a Shaw versus Reno kind of gerrymandering in the upper left plan that it drew. It was challenged in court. Court overruled it and gave the legislature a chance to draw another one. When it did not, the court drew the plan that you see at the lower right. Much less gerrymandered. Your eyes will tell you that it looks a lot better. And interestingly enough, was within a couple of percentage points for both the Hispanic voting strength and the African American voting strength. So the other lesson here is that you don't really need to do that kind of strange and bizarre gerrymandering to accomplish your purpose. So after the Shaw versus Reno cases, these principles typically apply. Usually you cannot raise race to the predominant consideration in any government decision, including redistricting. But it's okay, and you must, in fact, consider race in trying to satisfy Sections 5 and Section 2 of the Voting Rights Act. But you want to use race to the most limited extent that you have to accomplish those purposes, and that's called narrowly tailoring your plan. Bizarre districts aren't necessarily illegal, but they are a clue to the courts if you get challenged that you may have engaged in impermissible gerrymandering.